Do you have any a template or an example of this letter interfering with my rights?
I'm trying to remember what I gave the state of Alabama. I gave them something very extremely simple. I said to them, "This is the evidence that I'm going to use against you in a court. This is prima facie evidence. This evidence will stand undisputed. You will not be able to answer to this in a court of record." And I said, if I was you, I would make a settlement with me as soon as possible, and just something basically nice and gentle like that. And then I let 6 months go by, because I was basically relying like on the Federal Tort Claim Act of 1947, where the feds have 6 months to answer, because they say, well, we're a huge bureaucracy, and it takes us a long time. And I was in no hurry. I was building up my case. I was learning the law a lot better than I was, so I gave them 6 months. So I said, 6 months. I said, is there some reason why you failed to answer? And then they just said, we don't believe we owe you any money. And it was a funny answer they gave me. I love the answer they gave me. It's cutest. I'll tell you the answer they gave me. This is funny. The answer that they gave me was, by date modified. The answer that they gave me, what was the answer they gave me? DHR, here we go. I'm trying to see, reply. Their reply to me was, the DHR, which is like CPS or the Department of Human Resources, not Department of Homeland Security, it's DHR, does not believe that you have a claim. I was like, ooh, good, they said I had a claim. Because that's how I refer to it. A claim is a common law word, a claim. Like, I stake the claim for gold. I find a gold mine, I'm staking my claim. Ooh, good. So DHR does not believe you have a claim. DHR will not be paying you any money or giving you other relief. If you feel, oh good, only man can feel, if you feel that you have a claim, you should feel free to pursue your complaint in a court of law. So it's like, oh my God. So if they try to dispute anything for a common law court of record, a court of law is a common law court of record. That's a court of law, it's not a court of equity. There's two courts in this country, a court of law and a court of equity. That court of law is a common law court. So it's like, holy cow, the state attorney general's office sent me this letter. Like 6 months ago. They said they don't believe I have a claim. Oh, good. They don't believe? No, they can't believe they can maintain. Only man can have a belief. The state can maintain, but they can't believe anything. Only man can believe. So then it says DHR will not be paying you any money. So it's like, oh, good. So they must think they have something of value that I want from them. Well, as far as I know, the DHR doesn't have a printing press. They can't create any money, so I don't know what the hell they're talking about. And it says, if you feel that you have a claim, you should feel free to pursue a complaint in a court of record. So, oh, good. So they just said that they will no longer be talking to me on the administrative side. There will be more contact between me and you on the private side to remedy this matter outside of a court of law. So they're telling me, take me to a court of law. Okay, I'm going to grant you your wish. You want to go to a court of law? Holy cow, buddy. You realize what you just wished for? We're going to take you to a court of law. Here we go. And the only person who can speak in there is going to be the governor himself, the attorney general himself, and the trustee of the insurance fund, of the risk management of the General Liability Trust Fund, who's holding my money from me. Because I claimed, as a beneficiary of that fund, because I've been injured, because of those wrongdoers, I demanded X amount of dollars, and that trustee's holding up my payment. And he has no legitimate authority or lawful authority to deny my claim. I proposed him a claim. I told him the evidence. I gave him exactly why. I said, I'm a beneficiary. Give me it. He said, no, not without a court order. I said, oh, wonderful. So you want a court order? He said, yes. I said, buddy, in a common law court of record, who creates the orders? He said, what? I said, the prosecutor does. The plaintiff creates the orders. You want an order? You're going to love this order. And then I gave him an order. The orders are in there. Some guy named Tom Murphy read me the orders. He said, oh boy, I love your orders. They're one sentence long. I said, you're damn right. You're making an order to the waitress at Denny's for an order of pancakes. She's going to say, give me pancakes, sausage, and a biscuit. You're not going to give her 800 pages of how you want the biscuit made, or how to kill a cow, or how to pull a wheat, and how to shake the chaff off the wheat. I want 3 pancakes of bacon and a biscuit. You make it simple. And you tell them, oh, so give it to the clerk, now hand it to the state. They know how to say, I'm not going to grant this man, I'm not going to carry out this man's order. Good. No. Let's set this for a jury trial. Yay. Let's go. That's your answer? Yeah, good. Let's get the show on the road. You want to have a press-p day? You want a pre-hearing day? You want to get the matters of controversy out of the way? Let's do this. On day 22, we're going to be sitting in front of a jury. You ready to go? Let's go. I'm ready. And that's how I deal with them.
Well, if you're, you were going after them for money. Now they're coming after me for money.
Okay, well, then
How would I fashion that letter interfering with my rights if they're coming after me?
Why do they believe you owe? How do they believe that you owe them a debt?
Pardon?
You owe them a debt, huh?
They're saying I do, yes.
Okay, now who's claiming you owe them a debt?
The attorney for the plaintiff.
Okay, the plaintiff.
Certificate of tax sale.
An attorney can't make a claim. Only the plaintiff can. Only a man can make a claim. An attorney can't make a claim.
So what would the letter say?
So who's making a claim that you owe somebody money? If it's an attorney, that's filing a false claim, because an attorney can't make a claim. If that's the only instrument on record before a court, I don't care what kind of court it is.
Well, it's a complaint. Is that a claim?
Yeah, if he's claiming that you owe the debt. Somebody's saying that Miss New Jersey, you're from New Jersey, right?
Yes.
Miss New Jersey owes my, owes X, Y, and Z money. Okay, X, Y, and Z is going to have to come to open court, put their hand on the Bible, and swear on the oath of affirmation that you owe the money.
Is this how the letter reads?
What do you mean how the letter?
So you said the letter was to the judge. Letter number 1.
I said if the judge is interfering with your rights to say if who's ever interfering with your rights, you tell them to stop interfering with your rights. I said it could be a right to religion. It could be the right to free association. It could be the right to carry a gun. It could be the right to have a jury trial. So the letters just fill in a blank. Who's ever doing you wrong. So you're interfering with my right to carry a gun. You're interfering with my right to free association. You're interfering with my right to have a jury trial. You're interfering with my... And it can be addressed to anybody. See, my stuff isn't case specific. I'm not saying this is what you do to a judge, and this is what you do to IRS, and this is what you do to a credit card, and this is what you do to a mortgage company. This is what you do to everybody. You fill in the blank.
Okay.
Wrong.
Well, what would be the right they're interfering with for a jury trial?
If the judge was interfering with your right, you said to the judge, you put it in the paperwork way before you walked into the courtroom, and said to the judge, hey, you know what? I didn't get an answer back for you. I expected to get an answer back for you in 3 days. I told you by notice that if you don't give me a jury trial, you're going to interfere with my rights. Are you trying to have a hearing now today, and you're still going to try to conduct this matter without a jury present? Yes. Well, then, I'm sorry, ma'am. I don't know how to explain this to you. You're still interfering with my rights, and I don't know how you're going to proceed in this matter when I clearly established the rules, as I, the prosecutor, said that I will move a claim through your court. I'm not coming in as a freaking defendant. You guys got to stop saying you're the defendant all the time, because a defendant can never... There is nothing in the rules where a defendant wins money. A defendant always loses money, or he breaks even, but he never wins anything. Why do I always want to be the loser? I don't ever want to go in a game of chess or Monopoly and say the best I can do is lose. Why won't I play? What's in it for me? I don't see a reason for me to be here. You know what? I'm going to make a reason for me to be here. I'm going to be the winner. Somehow I'm going to win. I'm not going to play. So you're interfering with my right to a jury trial, right? Okay. Somebody's claiming I owe them a debt. Okay. Who's claiming the debt? An attorney can't make a claim. He can't claim anything. He has no idea what went on between me and the other party. He wasn't there. He doesn't know what we agreed to and how we were going to make the terms and conditions. He has no clue. He's coming in as a third. He's coming in, and so far in the end of this matter, it's scary. He has no clue what's going on. And I'm not going to sit here and explain, turn state's witness on myself and explain what actually happened between me and the supposed person who's claiming I owe them a debt. I'm not going to sit here and explain it. I've got to turn state's witness on myself. Let the plaintiff bring the information forward themselves. Let the plaintiff swear to it.
Do I tell the judge that the attorney can't talk and can't swear or bring in a claim?
You told the judge in writing this, right? Because you're not opening your mouth to the judge, right? You already established that you were never going to open your mouth to the judge, right?
Right, but how could I tell him that he's proceeding against me if I'm not in court? You said that he's having a hearing and I'm supposed to go into court, and I say you're still interfering with my right to a jury trial. Why? Because you're having this hearing. This is all in writing, not.
Like I said, you put it all in writing. if you go to court and if you want to read word for word what you said, Judge, what don't you understand in this thing? I said, I will appear when I see a jury present. I do not see a jury present. I will not be appearing today. You're interfering with my right to a jury trial. That's what it says right here on line number 2. Are you still are you still interfering with my right to a jury trial? You asked the judge, yes or no. I said, well, then there is no reason for me to be here today. What is the purpose of this matter, the hearing today? Because I don't know how you are going to move against me when you know you're in violation of the law. You're breaking the law, Judge. You're interfering with my rights. You can't do that. You can't outstep outside of your scope of authority. You took an oath of office to uphold and obey a certain sort of rules. Because you already established the fact that she is a judge and that she took an oath of office under Title 28, if you're going under a federal court judge, or under, like, say, I'm trying to remember, Title 4 or Title 5, or Article 6, Clause 3, where every state employee and every judge has to take an oath of office to be bound to the Constitution. So you're telling the judge, are you breaking your oath? Are you breaking your promise? Are you breaking your word that you contracted with the people to abide by the Constitution? Are you telling me right now, and you telling everybody in this courtroom right now, that you're not bound by the Constitution, and that you feel that you could breach your contract with the people, and that I'm just supposed to accept that? Is that what you wish to have happen today? But you put everything in freaking writing. There's no way in the world the judge is going to allow you. Like I said, when I do that to them, they all recuse themselves in the pre-hearing trial because they said, "Holy cow! I am not going to get into the courtroom with this crazy guy, Karl. He's going to tear me up. He's tearing me up in my own chambers. I'm certainly not going to let him put me on a public display and tear me a new hole. I'm going to recuse myself and say, oh, I know the person you're suing, Karl. I went to grade school with them. You know what? My sister had a barbecue with them last Thursday. I'm going to have to recuse myself." Every judge I go in front of, they all recuse themselves at the preliminary hearing in their chambers. They all recuse themselves because you put them on the spots there in their chambers. You set up a preliminary hearing date, a recipe date. That's how you nail all these judges. You don't wait until an open court. That's crazy. That's suicide. You put them all in their place in writing. You ask for a preliminary hearing trial. You establish the rules. This is how I'm going to appear. This is how I want them to appear. That's where I want the jury to sit. Judge, that's where I want you to sit. This is what I want you to do. That's what I want them to do. It's your case. You're packing the suitcase. I want my socks over here. I want my tissues over here. I want my Kleenex over here. I want my curlers, my iron, and my hairdryer over here. I'm packing my case. This is my case. My case, my suitcase, my case and my suit is going to be put on in front of the jury. I'm going to put on my suit in front of the jury. And they're going to determine the merits of my suit. They're going to say, hey, that's nice. I like the way you fucking did that collar. Yeah, it's pretty cool, ain't it? Yeah. They're going to see my accoutrements that I attached to my case. My witnesses, here's my exhibits, here's my testimony. Hey, I got a pretty cool suit in this case, don't I? Yeah, that's a pretty cool suit. It's American Idol. Yeah, we're your judges. Yeah, thumbs up. You win, buddy. It's all a game. It's all a show. You just got to know how to play it. Once you know how to play it, it's fun. Until then,
Getting back to this letter number 1, I'm saying you're interfering with my rights to a jury trial by jury.
Okay, I like that.
Okay?
Huh?
And that's only one line, and that's it. That's all I say?
Well, that's a good thing to say you're interfering with it. Then what I would do is I'd put the terms and conditions, and if you insist on interfering with my rights, and I appear on the 30th day, like you wished me to or you ordered me to, and I don't see a jury there, I'm going to be extremely upset, and I'm going to charge you $10,000 for wasting my valuable time, because you know the rules. Under Article 6, Clause 3, you took an oath to bound by the Constitution. I'm using my 9th Amendment, and I'm just going to use amendments right now, so I don't confuse you.
All right, I understand.
I'm going to say the 7th and 9th Amendments. I have the right to a court of record. That's the only court, that is the only form of court that's secured and protected by the Constitution of the United States. There is no other court established in the Constitution for the people. Everything else is due to an act of Congress. The federal district courts, circuit courts, Supreme Courts, are all, except for the Supreme Court, are all acts of Congress. The only other court that's mentioned is the Supreme Court of the United States, but that's the Supreme Court of the government of the United States. Not the Supreme Court of the people, it's the Supreme Court of the government to put the checks and balances between the executive branch and the legislative branch. That's all the Supreme Court of the United States was for the checks and balances of the government and the state. If the state had a problem with the feds had a problem with the state, they could go to their Supreme Court and slug it out. That's what the Supreme Court was built for. It wasn't built for us. Our court is a court of record. That's the 12 people in the jury. Seventh Amendment clearly stipulates once it's decided before a jury, it can't be retried, it can't be heard in any court in the United States, including the Supreme Court. It's simple.
Now, Carl, real quick, you write that letter to the judge, or do you put it in as a filing in the case?
Oh, you write it straight to the judge. You don't do none of this nonsense in the newspaper. If I was you, I'd send it to the judge. I'd send it to the Judicial Review Board of the state. I'd send it to the circuit court judge as well. That you got an out-of-hand crazy district court judge down here that is totally Looney Tune. But you don't say that. But at least they'll get the grasp of what you're trying to go with. So don't go too patriotic. Don't make it 800 pages long. Make it 1 page long, maybe 3 sentences, and you're done.
So you say, if you insist on having this hearing in 30 days and there's no jury present, I'm going to be extremely upset?
Yeah, you basically say it as nicely as you can. It's like, I'm going to realize that you still don't believe I have a right to, under the Constitution, that this matters more than $20, and you still believe that you have the right to interfere with that. I'm going to be highly upset, and I think your boss is going to be upset at the circuit court, and I'm already notifying him as well, and I'm putting you on notice. I'm letting your superiors know that they're going to be held liable, and you can do that, say, writ of mandamus thing that I'm demanding. I want to demand of them that you obey the law. And if you don't obey the law, they're going to take over. So how are we going to do this, ma'am? Or how are we going to do this, Judge? Sir, how do you want to play this game? You want me to put you on notice with your boss and say that you're not holding up your oath of office? Where do you want me to go with this, sir?
So will I expect an answer?
I hope they don't give me an answer. What do I want an answer for?
If they don't answer, you say they're acquiescing.
I'm suing them.
To the fact that you're going to get a jury trial.
I'm going to prove to the jury. I gave them time to answer. They refused to answer, jury. You know the rules. He knows the rules. The maximum law, tacit acquiescence, is acceptance of the rules. There you go. They accepted
that's your second letter? You write your second letter?
Mine
just acquiesce?
No, you put that in your first letter. Say if you refuse to respond, if you fail to answer, you know the maximum.
Okay.
If you answer in 72 hours or 14 days or 6 months, that, I'm going to use this as a form of tacit acquiescence to prove that my claim is just and true and fair. And I'm going to present this to the jury as evidence of why I'm suing you. You can sue somebody for interfering with your rights. Nobody's immune to doing. Nobody can interfere with your rights. You claim you got a right, nobody can deny you right. Your rights can't be surrendered, they can't be revoked, they can't be taken away. There's no such thing. If they could take away your right to do something, it's a civil privilege. It's not a right.
Okay, we got to move on because we are running out of time and people are in line.
Go for it.
All right. If there's any way you could give us the procedure after that to establish the case in the federal court.
Like I said,
your own sausage.
You just basically told the other side that you said in the first letter. You said, if we can't settle this matter on a private side, I am going to move it to a common law court of record in a federal district court, because obviously I'm not going to get a fair hearing in a state court, because you're a state judge. You get paid by the state. Obviously your buddy's going to back you up. So you know what I'm going to have to do? I'm going to have to take you into the federal court. How do you want to deal with this lady? And then you got to make sure, like the federal rules say, you got to abide by certain federal rules. You got to say, look, I can't, she's interfering with my rights. It's a federal question. You just say it's a federal question. You let the federal district court judge decide whether or not she had the right to interfere with your rights to a jury trial. And like I said,
hitting yourself now, it's getting late. We got to move on.
Right. That's why I said to people about declaratory judgments. You could write to the federal district court judge and give him a declaratory judgment. Ask him, can you give me your opinion, federal district court judge? I got a state lady judge who's giving me a hard time interfering with my right to a jury trial. Can you give me my standing if I brought it before you? How would you rule on that? And the judge will say, well, okay, the state judge lady is giving you a hard time. Yes. Okay, this is her standing, this is your standing, you're using Article 6, Clause 3, and she's ignoring you, right? Good. He'll give you the opinion. And then he'll send the opinion to the judge lady, and he'll say, now, judge lady, you still want this lady to drag her into federal court, because I already ruled in her favor. Because now when she comes here, she's going to win in a half of a heartbeat, because everybody here at the federal district court already is aware of what's going on. So, are Are you sure you want to settle this on a private side? That's a declaratory judgment.
Okay.